The Fourth Amendment to the U.S. Constitution protects us from unreasonable search and seizure by the government. According to Radley Balko, in his book, Rise of the Warrior Cop, the Fourth Amendment was specifically crafted as a result of the abuses American colonists had experienced under British rule. The Fourth Amendment reads in part, "No warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." It may be argued this wording is nothing more than a curiosity to the average American citizen and escapes notice since the tenets of the Fourth Amendment have been well established by case law over the past 100 years. To the colonists, however, this wording was incredibly deliberate and incredibly specific. Mostly lost to history are what was known to the British and colonists as general warrants. A general warrant during American colonial times was issued by the British government so that authorities could investigate an offense, most commonly offense against the Crown. A general warrant was neither supported by oath, nor did it specifically describe the place to be searched or the persons or things to be seized. Essentially, a British authority with a general warrant could search any place and seize any person or their property merely suspected of being involved with an offense. The general warrant was not confined to a particular person, location, or piece of property. It was essentially a roving and unrestricted authority for the Crown to enter any place, arrest any person, and seize any property they thought might be involved in the offense, no matter how indirectly. Obviously, the potential for abuse was great, and the colonists despised and hated general warrants. Thus, the specific wording of the Fourth Amendment. Today, the Fourth Amendment protects us from unreasonable searches and seizures. All searches and seizures without a warrant are initially presumed to be unreasonable. However, there are many types of searches which the courts have determined are reasonable without a warrant. A search warrant under the U.S. Constitution must contain probable cause, including facts and circumstances which would lead a reasonable person to believe a crime had been committed or a person had committed it. And as previously stated, warrants must identify what is to be seized, such as a person or object, and name or describe the person, place, or thing to be searched, essentially the who and where. The Texas Code of Criminal Procedure further requires the warrant to command a peace officer to search and to be signed and dated by a magistrate. Both the Texas Constitution and the Texas Code of Criminal Procedure echo the Fourth Amendment to the U.S. Constitution. The Texas Constitution and the CCP both state the people shall be secure in their persons, houses, papers, and possessions from all unreasonable searches and seizures. And no warrant to search any place or to seize any person or thing shall issue without describing them as near as may be, nor without probable cause supported by oath or affirmation.